All right, good morning and welcome to Digital Ethics and Risk Management in Psychosocial Oncology Cutting Edge Challenges presented by Dr. Reamer. My name is Kelly Hendershot. I'm Vice President of Mission Delivery at Cancer Support Community, and I will be moderating the session. And before I introduce Dr. Reamer, we just have a few housekeeping items that we want to cover with you. First, the session is being recorded and it will be available for viewing after the event. All registrants will receive an email post-event with details on how to find the recordings. But a reminder that to receive the continuing education credits, you have to watch the live virtual sessions, not the recordings. If you wish to receive credit from participating in the session, you will need to complete an online evaluation form. Links to that will be shared throughout the day. And credit can be claimed up until December 20th. If you have any questions that you'd like to ask during the presentation, please go ahead and use the chat tool, the Q&A tool rather. I'll monitor the chat in case we have any questions that sneak in there as well, but we will hold questions until the end. And then if you would like, you can turn on closed captions by pressing the CC bottom. It should be in your Zoom toolbar. Now I'd like to introduce our presenter. Frederick Reamer has been on the faculty of the School of Social Work, Rhode Island College since 1983. His teaching and research focus on professional ethics, criminal justice, mental health, healthcare, and public policy. Dr. Reamer received his PhD from the University of Chicago. I was just there last week, and has served as a social worker in correctional and mental health settings. He's chaired the National Task Force that wrote the Code of Ethics adopted by NASW and served on the code revision work as well. Dr. Reamer also chaired the National Task Force sponsored by NASW and the Association of Social Work Boards, Council on Social Work Education, and Clinical Social Work Association that developed the standards governing social work's use of technology in professional space. So you can hear already we've got an expert with us. Dr. Reamer has lectured nationally and internationally on social work and professional ethics, including in India, China, Singapore, South Korea, Taiwan, and in various European nations. So please welcome Dr. Reamer.
Thank you, Kelly, for the kind introduction. Glad you got to my alma mater last week. You saw those beautiful gray Gothic buildings there, I hope. How about that? How about that? Good to be with you folks. I recognize that it can be a bit of a challenge sitting in front of a screen yet again, listening to somebody present remotely, and I'll do my best to keep you engaged. We have a lot to cover in a relatively short period of time. So let's get to it, right? Digital ethics and risk management in psychosocial oncology, cutting edge challenges. I'm going to talk about a number of issues today that I suspect were not included in whatever professional education you got, whether it was in social work or in psychology, psychiatry, mental health counseling, marriage and family therapy, nursing, what have you. We are now dealing with various forms of digital and other forms of technology to serve clients and patients and to communicate with them outside of so-called normal working hours, whatever those are, and engaging with some people on online social networking sites using technology that didn't exist when many of us, myself included, started our careers. So I have four things in mind for our discussion today. Number one, I want to talk about ethical and risk management challenges in what I call the digital age, and I'll give you a bunch of examples, right? Number two, I want to talk about ethical and legal standards in the digital age, and those are not synonymous, right? Ethical standards related to technology use, to deliver services to clients and patients, to communicate with them using technology, to store information in electronic records and charts. There are ethical standards pertaining to a lot of this, and there are some relevant legal standards as well. I'm not an attorney. I cannot offer legal advice, but I can share with you my understanding of various statutes and regulations and even case law that is relevant to the issues I'm talking about today. Number three, I want to talk about standards of care. in social work, the behavioral health professions more broadly, pertaining to our use of technology in all these different ways. Some of you, I suspect, are familiar with that three-word phrase, standard of care. If you're not, it is so important. It is so important to understand the implications of that three-word phrase. I'll get into that a bit closer to the end of my presentation. And finally, I want to talk some about risk management in this so-called digital age. I want to talk about some of the policies and protocols that I think contemporary practitioners and their employers need to have in place in order to comply with prevailing ethical and legal standards. Some of you may have started your careers at a time when you used one of these things. May they rest in peace. Remember those? Some of you? A rotary phone. Not anymore, right? Once upon a time. And some of you started your careers at a time when, if you wanted to talk to a client or patient, you actually met with them in a room, a physical room, not a Zoom room, and you sat in chairs and you were a few feet apart and you looked at each other's faces in person. Remember those days? Right. And now, of course, we have the very, very high likelihood that many practitioners are communicating with their clients and patients remotely. Notice the outfit, right? From the waist up, got to get dressed up, right? Things have changed. And we know that some of this happened as a result of the onset of the pandemic in the spring of 2020 when COVID fell out of the sky unbidden. But of course, many practitioners were using remote services even before the onset of the pandemic. I most recently embarked on a project focused on the implications of artificial intelligence in social work and behavioral health more broadly. And if you're not aware of the ways in which artificial intelligence is now being used in health and behavioral health care, you're in for a big surprise because it is here. And I don't think we're going to unring this bell. The bell has been rung. And I could spend several hours talking about the ways in which artificial intelligence is now being used in healthcare and behavioral healthcare to provide crisis intervention services, to provide resources to patients and clients, to supervise staff, to record clinical encounters using AI software, and on and on and on. Unless you finished your formal education about, oh, I don't know, 10, 12 minutes ago, you went to school at a time when none of this was taught, none of it, or very little of it. So I have 5 things in mind. I want to reflect on the ways in which I think technology has altered, and I mean fundamentally altered, the nature of behavioral health care, generally in psychosocial oncology care in particular. And I think technology has been transformative, some of it with good outcomes, some of it not so much. Secondly, I want to identify compelling ethical issues related to practitioners' increasing use of technology to serve and communicate with clients and patients, access and store digital information, and so forth. Third, as I mentioned before, I want to talk about relevant ethical, legal, and practice standards. And I'm using that term deliberately. Practice standards, those are not the same as ethical and legal standards. More about that later, related to behavioral health and technology. I want to talk concretely about the steps I think today's practitioners need to take to protect clients and patients, always our first priority, of course. And I also want to talk about practical steps. I mean, practical steps that I think today's practitioners can take to protect themselves, to prevent ethics complaints and malpractice claims. Now, one of the things Kelly didn't include in the bio, because I didn't ask her to include it, is that I spend an enormous amount of my time serving as what the courts call an expert witness. What's an expert witness? I have to raise this hand. This one does not count. I have to raise this hand, my right hand, and I have to solemnly swear to tell the truth, the whole truth, and nothing but the truth in many, many lawsuits, litigation cases throughout the United States involving behavioral health practitioners who allegedly engaged in negligent conduct. And often these cases involve allegations that practitioners used technology to deliver services, to communicate with clients and patients, to store information in the proverbial cloud in ways that were negligent. And my role is to testify about whether I think the practitioner's employer, did or did not meet prevailing standards pertaining to the use of that technology. I also serve as an expert witness in many licensing board cases. And I can tell you with no hyperbole, no exaggeration, that an increasing percentage of licensing board cases involve allegations that practitioners did not use technology responsibly. And I can also tell you this from firsthand experience in recent years, over and over and over and over again. If, heaven forbid, you are ever named as a defendant in a lawsuit or as a respondent, that's the noun we use, a respondent in a licensing board case, I can pretty much guarantee you every single text message you've exchanged with a patient or client that's relevant to that case, every email message that's relevant to that case, every note in an electronic record or chart, any online social networking post, Facebook, Instagram, LinkedIn, what have you, anything that's relevant to that case will be subpoenaed and will likely be displayed in the courtroom during deposition testimony and in licensing board hearings on a large LED screen in that room. I now see it regularly, and none of this occurred when I started my career. Technology matters. It matters a lot. So, in my opinion, and by the way, I'm going to share my opinions, and I encourage you to share yours, which might even differ from mine. Feel free to share your thoughts, your opinions, your comments, even if they differ from mine. I believe in the free exchange of ideas. So, in my opinion, technology has introduced 5 fundamentally challenging questions for those of us in the behavioral health world who care about oncology care. What do we mean by relationship? Particularly when some of the people to whom you provide services, you may never meet in person. You may not even see their face because they may be self-conscious about their appearance, and you may be communicating with avatars. Yes, avatars. Avatars. Those are graphic representations of clinicians and clients and patients, people who may not be comfortable showing their face. What do we mean by relationship? Who do we aim to serve? Now, I'm a social worker. And one of the principal reasons why I'm a social worker is that the social work profession explicitly aims to serve the most vulnerable people on our planet. Now, social workers like psychologists and mental health counselors and marriage and family therapists and nurses and psychiatrists are concerned about everybody, of course. But social work has embedded in its mission statement, a mission statement which I was privileged to have written when I chaired the task force that wrote the Code of Ethics for the social work profession. It's embedded in the Code of Ethics that we pay particular attention to people who are living in poverty, people who are oppressed, people who are victims of trauma. It's in the Code of Ethics. And I'm concerned about how the proliferation of technology, which can be very expensive, may limit our ability to serve people who are living in poverty, people who can't afford a smartphone, people who can't afford a generous data plan, people who can't afford internet service. I'm concerned that the proliferation of technological tools in behavioral health care may limit our ability to serve the most vulnerable. Third, what are the boundaries of professional client relationships? Now, anybody who's gotten decent training in a behavioral health profession has learned about boundaries, right? Dual relationships. The kinds of issues we've been talking about for decades, things like How do you respond if a client or patient asks you personal questions? How old are you? Where do you live? Do you have any kids? Have you ever been diagnosed and treated for cancer and treated for cancer? Right? Self-disclosure issues. I imagine some of you have been invited to clients and patients' weddings and baby namings and bar mitzvahs and the boundaries of accepting those invitations. Some of you have been given gifts, no doubt, by clients and patients and their boundary issues pertaining to whether one ought to accept a gift. Some of you, I suspect, live and work in relatively small communities. It's not a question of if you bump into the client or patient at church, at the supermarket, or at the PTA meeting, where your kids, by the way, might share the same classroom and want to have a sleepover, right? You've got to manage these boundary issues, these dual relationships. These are long-standing boundary-related challenges. But in the digital age, I think we have a new set of unprecedented boundary issues, right? Responding to Facebook requests, right? By a current patient or client. Is it okay to accept a Facebook friend request from a former patient or client? What are the boundary issues there? Is it appropriate to communicate with a patient or client using technology late at night on a weekend? What are the boundary issues? Is it permissible to conduct an online search using one of the powerful search engines, not just Google and Bing, right? But also DuckDuckGo, which, by the way, is not a joke. That's a very powerful search engine. One I happen to like, DuckDuckGo, not DuckDuckGoose. That's a kid's game, of course. Is it appropriate to conduct an online search for information about clients or patients without their knowledge, without their consent, right? If you didn't know it, there are now national ethics standards on that very issue, which I helped to create, the boundaries of online searches. And I suspect that many of you know for a fact that some of the patients and clients you serve have conducted online searches for information about you. And they are finding a lot of information about where you went to school, about your family, if you ran a marathon, the time of your run, because it's posted on some website, right? If you just announced your engagement, it's on somebody's website. Patients and clients are finding out a lot about us because they're searching for it, and that creates a novel boundary issue. Fourth, what do we mean by informed consent? That's not a new concept. Informed consent, of course, has been central to health and behavioral health for decades and decades and decades and decades and decades. But I now get involved as an expert witness in litigation and licensing board cases where practitioners and agencies were not using state-of-the-art consent to treat protocols involving technology, where they were serving patients and clients remotely. They didn't have a consent protocol tailored to remote delivery of services. That includes things like what to do if there's a technology failure, making sure that the client or patient confirms their geographic location, because if they are sitting in a state where you're not licensed, you, according to most licensing boards, are now providing services in that state. And if you're not licensed in that state, you can have a problem. What to do if the client or patient has an emergency and they're located 312 miles away, and on and on and on. We need state-of-the-art consent to treat protocols that include, by the way, a social media policy. When many of you finished your formal education, sorry about that refrain that I'm repeating, I suspect there was no such thing as a social media policy that explains to clients and patients how practitioners conduct themselves online, that you can't be the Facebook friend, and how you're going to handle online searches, and letting clients and patients know that if they're having a crisis, they shouldn't text you because you may not see it in a timely fashion. All that needs to be embedded in a social media policy, which for the social workers out there is now a national requirement that you'll see in two different places: the NASW Code of Ethics, it's in there now, and national practice standards, which I'll discuss later. And finally, how do we manage and access clinically relevant information? Right? So you probably know, I hope you know, that under almost all circumstances, clients and patients have a right to see your clinical notes, right? Well, if you have electronic records, right, when many of you started your careers, I suspect you used one of these things. This is called a pen. I don't know if you've seen one of these lately. Some people still use them. Many of you, most of you perhaps, are using electronic records, electronic charts. I hope you're familiar with what is called the 21st Century Cures Act, not the CARES Act, not the CARES Act, that's for pandemic funding. The 21st Century Cures Act, which is a very strict federal law that governs health and behavioral health practitioners' legal obligation to provide clients and patients with copies of their electronic records if they request them, right? Electronic records are now central to that law. Okay, so if I could wave the magic wand, I don't have a magic wand, but if I could wave the magic wand, I would say that in this so-called digital age, there are three things we need to really master in order to protect clients and patients and also to protect ourselves. So when I think about what I've learned over the decades about managing ethical challenges, what I've learned about in recent years regarding the use of technology, I would say there are three things we need to know. First, ethical dilemmas that arise particularly related to our use of technology. So, behavioral health practitioners have been concerned about ethics for a long time, especially since I would say the late 1970s. It's about when the subject of professional ethics and applied ethics, or what's called practical ethics, started. Some of you may know the history. Until the late 1970s, the word ethics meant Socrates and Plato and Aristotle and John Stuart Mill and Jeremy Bentham and Immanuel Kant and Confucius and people like that. It was in the 1970s when the field of bioethics, the practical application of ethical standards, ethical concepts, ethical principles, ethical theories to the real life challenges that health and behavioral health professionals face, initially primarily in medicine, but it's broadened since then, of course. Ethical dilemmas. How do we manage conflicts between our duties and obligations? How do we make the difficult choices related to use of technology in psychosocial oncology care? So, for example, at the peak of the COVID-19 pandemic, which I don't think is over, the pandemic, but I think the peak, is a bit in the rearview mirror, fortunately. We're managing this better, I think. But at the peak, I imagine some of you were providing services to people you could not see in person. And they may have had very challenging mental health symptoms, suicidal ideation, right? Some psychotic features, who knows what. And you perhaps did not feel comfortable serving them remotely, but you didn't have a choice. So, how do you manage that ethical dilemma? How do you manage an ethical dilemma when you have a patient or client who shares some really sensitive information with you about what's going on in the family, where there's a legal dispute within the family, and your clinical notes might end up being subpoenaed? And you have to make a decision, an ethical decision about whether to be vague in your notes or whether to be detailed and explicit in your notes, given who might have access to those notes down the road during legal proceeding. You have a patient or client who asks, consistent with the 21st Century Cures Act, to see all of your notes. Your patient, your client wants to see your notes, which they typically have a right to do. And you realize, reviewing your notes, that there are some statements in there that might deeply offend or hurt the patient or client. And you're not comfortable sharing those, right? You got to make a decision about whether you're obligated to share everything or whether you can be selective under the law. and under ethical standards. P.S. I hope you're familiar with HIPAA's provision, known as the psychotherapy notes provision, right? Those two words, psychotherapy notes, not psychotherapy progress notes. That doesn't count. Not progress notes. That doesn't count. Those literal two words, psychotherapy notes, under HIPAA, you are allowed to keep certain notes that diagnose, assess what goes on during a clinical session, what we call a memory jog, notes that you are not comfortable sharing with the client or patient. They're meant for you only. You do not have to share those. The law says you don't have to share those. But many practitioners I know are not familiar with that provision in HIPAA, are not familiar with the criteria regarding what constitutes a psychotherapy note. This is important to know to manage these sorts of ethical dilemmas. Suppose you think a patient or client is high risk, has not been telling you the same set of facts consistently. You're not sure what's true, what's not true. Is it okay to do an online search for information about those details for clinical purposes? That's an ethical dilemma that's addressed in prominent codes of ethics. And when these ethical dilemmas arise, pertaining to things like confidentiality and boundaries and dual relationships and informed consent, and the use of technology to serve people who may need a higher level of care, et cetera, et cetera, et cetera. How do you make these decisions? The second bullet point. How do you make these decisions? What do you need to know? And I will tell you that in most of the graduate programs that I know, I can't speak about all of them, of course, but in the ones that I know, there is now a much more deliberate, explicit effort to, number one, identify ethical dilemmas that might arise in one's work, for example, in psychosocial oncology care, and to learn about ethical decision making protocols, frameworks, ways to make these decisions. These are not formulas. You don't just pop in the data and out comes the answer. In fact, with a lot of really challenging ethical dilemmas, there are reasonable differences of opinion about the right thing to do. But I think there are some really valuable ethical decision making frameworks that we now teach regularly. And the third element of what I consider to be core ethics knowledge in the digital age has to do with what I call ethics risk management. That is, what do we need to know to protect clients and patients, number one, and as I mentioned earlier, to protect ourselves when using technology, especially if we want to prevent lawsuits and licensing board complaints. Here's the good news. The overwhelming majority of health and behavioral health practitioners who are concerned about cancer care will never be sued, never named in a licensing board complaint. Most things in life I know nothing about or very little, but I know the statistics on this. And that is, we're not likely to get sued or named in licensing board complaints. That's the good news. Here's the bad news. Lots of people are sued. Lots of practitioners are named in licensing board complaints. It's a small percentage, but that's how I spend a great deal of my professional time dealing with these cases. In the digital age, I think there are 5 especially compelling ethical challenges. I've already mentioned some of them briefly, so I won't spend a lot of time on this slide. This is not an exhaustive list, but I think this is the list of the most common and complicated ethical challenges that I see in the so-called digital age. With regard to confidentiality and privacy, we need to know how to protect PHI. When many of us started our careers, myself included, PHI was simply part of the name of a fraternity or a sorority, Alpha Delta Phi. Now it's protected health information. It means something really different. And we need to know, if we're using technology, about the use of HIPAA compliant software. For example, I get involved in cases, litigation and licensing board, where very well-meaning counselors, social workers are texting their patients, texting their clients using the text feature that came with their smartphone from AT&T, T-Mobile, Verizon, whatever. I would never do that. That is not HIPAA compliant texting, right? that, in my opinion, if we're going to text or email patients and clients, we need to be using one of the many products that are out there that encrypt those text and email messages, what's called end-to-end encryption. Otherwise, we, number one, are violating ethical and probably legal standards and expose ourselves to risk because we are communicating PHI, right? Even if it's just for scheduling purposes. That's PHI, according to every lawyer I know. I mentioned earlier decisions we need to make sometimes about searching online for information about clients, right? There are national standards governing when it is, when it's not appropriate to conduct an online search. I think we need to know about those. We need to implement them. We need to know how to do the triage. Is this an appropriate search or not an appropriate search? What kind of consultation should we be getting? And should we be documenting it in the chart that we did the online search? Frankly, I think we should. I think transparency is important with regard to informed consent, right? Are you using consent decree protocols that address, for example, the use of public Wi-Fi, advising clients and patients not to use public Wi-Fi when they are sharing very personal information online? Confirming the client's geographical location for a remote session. The issues I mentioned earlier about what to do, what the patient or client should do if there's a technology failure, if they need to manage an emergency, a document that explains the limitations of remote service delivery, right? And now, most recently, if anybody in the audience today is using artificial intelligence, making sure that patients and clients understand the potential benefits, but also the potential risks associated with the use of artificial intelligence. Number three, boundary issues in dual relationships, decisions we make about searching online for information about clients, but also the boundary issues that can emerge when they, patients and clients, search for information about us and learn about our personal lives and ask questions about that. I think that's a very challenging boundary issue sometimes. I'm not someone who says never self-disclose. I have self-disclosed selectively with some clients, some patients, but I have criteria in mind about when I think self-disclosure is appropriate, what I call judicious self-disclosure, and when it's not, what I call gratuitous self-disclosure. And there's literature on all of this, and a lot of this is now taking place online. How to respond to patients and clients' Facebook friend requests. The issue I mentioned earlier about whether it's ever appropriate to be a Facebook friend with a former patient, a former client. Guidelines concerning after hours digital communications. I testified in a case in the state of Maine where a former client, actually the parent of a client, filed the licensing board complaint, and a very core element of that complaint had to do with alleged boundary violations because the clinician communicated online on Facebook late at night with a patient who was an adolescent, a minor. And those Facebook communications, which had a lot of clinical content, were introduced as evidence in that case. And I had to testify about those boundary issues. Documentation, the fourth bullet point there. The 21st Century Cures Act that I mentioned, the strict federal law governing clients and patients' remote access to electronic records. A number of challenges I've seen with electronic health and medical records. Clinicians who, to save time, copy and paste a note from an earlier clinical encounter. I understand the wish to save time. I get that. And they didn't proofread the pasted note. And in the third sentence, there was a statement of fact that was true a week ago, but not true today. But it's in the record and it's in there permanently. And that record gets displayed on the screen in the courtroom or the licensing board hearing room, and the optics are awful, right? Some of you may work in integrated health, behavioral health settings, and I'm a big fan of integrated health, behavioral health settings. I believe every integrated setting must have strict firewalls governing who can and who cannot access behavioral health practitioners' clinical notes. right? I don't think everybody in an organization should have access to those notes. I think only those employees who have a need to know, air quotes, a need to know that information as part of their job should have access to those notes, right? And I get involved in cases where organizations didn't set up those firewalls sufficiently, in my opinion. And then finally, issues related to termination of services and client or patient abandonment. As I mentioned earlier, those instances where we're providing services remotely and clients or patients need a higher level of care, or we cannot respond in a timely fashion when a patient or client is in crisis and sends the text message, for example, or they send it, late at night on Saturday, and we don't check the messages until Monday. I was involved in a case recently where a clinician had a voicemail box. We all have voicemail boxes these days, but hadn't cleaned it out. And a patient who was in crisis tried to leave a message and got the mailbox is full, couldn't leave the message. And it was a genuine crisis, right? And the clinician was held responsible because she had not deleted messages, made room for new messages. Take a look at the list of terms on this slide, right? Think about your graduate school education. Were any of these terms mentioned? I suspect not. Again, unless you're a very recent graduate. So our vocabulary has changed. There are now 3 sets of national standards pertaining to technology use that I think we need to know about. Ethical standards. So I know we have various professions represented here today. We have social workers, perhaps psychologists, marriage and family therapists, psychiatrists, and so forth. Each profession, of course, has its own code of ethics. Counseling has 3 of them. That's another story. I don't fully understand that, but they got 3 of them. Ethical standards in codes of ethics now typically include language concerning ethical use of technology for all the purposes that I've described today. I'll give you a couple of examples before we end this session. Regulatory standards. What are regulatory standards? You may recall that there are several different kinds of law. There's statutory law, legislative branch of government. There's case law, the judiciary, right? Court system. And then there is regulatory law, meaning the executive branch of government, right? Those of you who are licensed, and I suspect that's most of you, your license is governed by regulations. In every profession I know, there are standards related to ethics embedded in the regulations governing your license. And licensing boards around the world, not just in the United States. You may have heard in the intro, and Kelly mentioned that I've lectured in a number of other countries. I know that regulations, licensing board standards increasingly include language about the appropriate and inappropriate use of technology. These things have been upgraded and revised. And then there are so-called practice standards. What are practice standards? These are guidelines adopted by national organizations, the American Psychological Association, the American Psychiatric Association, AMFT for marriage and family therapists, NASW. And I chaired the national task force that Kelly mentioned earlier to establish practice standards, ethics-informed practice standards for the social work profession, co-sponsored by 4 large organizations governing use of technology. So I think we've got to find out. If you're not familiar with them, got to find out, got to read, got to review. Not fun, but I think essential. The relevant ethical standards, the relevant regulatory standards, the relevant practice standards pertaining to your use of technology for any of those purposes I mentioned before. And if you look across those different standards, and I've been involved in the development of all 3 of them. Code of ethics for social work. I chaired the task force that wrote the code of ethics for the social work profession. and participated in a task force to add technology-related standards. I chaired the national task force that established practice standards for technology use in the social work profession. And I also chaired about 10 years ago an international task force sponsored by the Association of Social Work Boards to develop model regulatory standards pertaining to technology use that many licensing and regulatory boards around the world are now using. And if you look across those, you will see that there are six major themes. And I've already mentioned most of these, so I'll be very brief. Guidelines concerning informed consent when we're using technology, what needs to be in the informed consent protocol. Guidelines concerning privacy and confidentiality, addressing things like encryption safeguards, and if you're doing online group counseling, making sure there are confidentiality agreements and the participants agree that nobody else will be in the room during an online group counseling or support group session. That needs to be in that guideline, I think. For those of you working with collaterals, the spouses, the partners, the adult children, making sure that you have collateral agreements when you're providing services online. I would do that in person as well to ensure that the collateral fully understands the nature of their confidentiality rights and the limitations, because they're not clients. They're not governed by the client or the patient's confidentiality protection. Guidelines concerning online searches, as I mentioned earlier. The practice, ethical, and regulatory standards to which I've referred also address lots of issues pertaining to boundaries, dual relationships, and conflicts of interest when we're using technology. And I list some examples there. Fourth, they address issues of practitioner competence. Now, let's face it, some of us are really tech savvy. We're comfortable with all kinds of bells and whistles. And others of us are like, how do I turn on the computer? And how do I mute myself on Zoom? And how do I share a screen? Basic stuff. Well, if we're going to use technology to serve clients and patients, of course, we need to be competent with regard to state-of-the-art technology and encryption and all the issues around interjurisdictional delivery of services, cultural considerations. Some clients and patients may not be real comfortable with this technology. Guidelines concerning records and documentation, clients' access, patients' access to records, the importance of encryption in our records, and also an issue I have not yet mentioned, but I will now, collegial relationships. And yes, all three of these sets of guidelines address our obligation to treat each other well online, colleague to colleague. And the only reason my colleagues and I put those guidelines in there is because there have been some issues when people have not behaved well online when talking about, posting about, or interacting with colleagues. There are three patterns that I've noticed over the years with regard to issues that emerge. Number one, ethical mistakes. Good practitioners who make inadvertent errors. They upload the wrong EHR. They send an email blast to a number of clients or patients, and they use CC rather than BCC, which meant they were disclosing the identities of other patients and clients. I'm involved in a licensing board case right now where a clinician made that mistake. What we call auto-population errors, where certain fields in the electronic record may be automatically populated and the information that is automatically populated is not accurate, but the clinician didn't proofread carefully and correct it. Deliberate ethical decisions, the judgments we need to make sometimes about whether to terminate services, remote services, to someone who needs a higher level of care. Decisions we make about conducting online searches. Decisions we make about whether to provide emergency services across state lines when you're licensed in Wisconsin, but the client or the patient is in Orlando, Florida. I hope not today, given the weather there during the next few days, and you're not licensed in Florida. How do you handle that? And the issues I mentioned earlier about use of artificial intelligence, whether to use it, whether not to use it, if we're going to use it, how to do it responsibly. And then sadly, I've been involved in too many cases involving ethical misconduct involving um, inappropriate online exchanges with clients and patients, which included some sexual content. No kidding. Fraudulent electronic billing and documentation, otherwise known as fraud. Those are the three patterns that I've seen. And here I list some of the most common risk areas that I've encountered in my career. And I want to finish my comments before we open it up with some observations about that concept I mentioned earlier, standard of care. So here's what I know to be true. If questions ever surface about whether practitioners handle their use of technology responsibly, and these questions come up in the lawsuits in which I'm an expert witness and licensing board cases in which I'm an expert witness, where some disgruntled party is alleging inappropriate use of technology. And in every single case, and I've been in lots of them, the question I always get asked by the attorneys, Dr. Reamer, now that you've reviewed all the evidence, you've interviewed the parties, examined the relevant standards, in your professional opinion, did the fill in the blank, social worker, psychologist, counselor, nurse, whatever, meet the standard of care, that is, use technology in the way that a reasonable and prudent professional with the same or similar training would have done under those circumstances? That's the question I always get. And sometimes it's very clear cut, right? You shouldn't have sent a sexualized text message to a patient. Shouldn't have done that. That one's easy. But I would argue that there are lots of ethically complex cases when even we who are thoughtful, reasonable, prudent, disagree about whether the practitioner should have done the online search, should have withheld certain statements that are in the electronic record from the patient or client, should have been a Facebook friend with a former patient or client. Was any of that appropriate? We may disagree some. So I think the key question to ask is, what do you do in ethically complex cases when reasonable and prudent practitioners don't agree on a course of action? What do you do? What do you do? And I argue in one of my books that there are 10 things, 10 things. If we don't agree on a substantive standard of care, 10 things that I think greatly enhance the likelihood that we will protect clients and patients, number one, and also protect ourselves. Knowing when to get consultation and supervision. I know that's easy to say. Really being familiar with relevant ethical standards related to technology use, being very familiar with relevant laws pertaining to technology use, being familiar with relevant agency policies for those of you who are not in private practice related to technology use, being familiar with national practice standards, ethics informed practice standards related to technology use, ideally being familiar with relevant literature on the use of technology in the behavioral health context, knowing when legal consultation may be necessary. For example, if your patient is located in another state in which you're not licensed and there's an emergency, is it okay to provide services across state lines in a jurisdiction where you're not licensed, where that state may require you to be licensed? For those of you who work in a hospital, especially, consulting the ethics committee. Almost every hospital now has an ethics committee that's available for consultation. If, heaven forbid, you smell a lawsuit or a licensing board complaint, notifying your malpractice insurer if you think there may be a problem, and documentation, documentation, documentation. So if there's time, I want to give you some examples of some of this technology to which I've referred, but I also want to provide you with an opportunity to ask questions and share your thoughts about any of these issues. So I'll take the PowerPoint down and we'll open this up. Kelly, what do we have?
Okay, we do have a few questions from various locations. The first is, can you distinguish the difference between psychotherapy notes and progress notes?
Sure. So under HIPAA, a psychotherapy note, and let me, while I'm talking, let me see if I can pull it up real fast and show it to you. So under HIPAA, and when I pull this up, Kelly, feel free to grab it if you want, or I can put it in the chat. All right, so let me go here and all right. So this is the federal website. This is the federal website. You know what? I'll stick it in the chat for anybody who wants it. And I think I have to do everyone. Here it comes. Okay. So this is the federal law. And it says generally the privacy rule, and the privacy rule is the same as HIPAA, that's a synonym. The privacy rule applies uniformly to all protected health information, PHI, without regard to the type of information, but one exception to this general rule is for psychotherapy notes, not progress notes, not psychotherapy progress notes. Psychotherapy notes, that's the term in the law, which receives special protections. The privacy rule, HIPAA, defines psychotherapy notes as notes recorded by a healthcare provider who is a mental health professional, that's you folks, documenting or analyzing the contents of a conversation during a private counseling session or a group, joint, or family counseling session, and that are separate. They have to be segregated from the rest of the medical record. So, to put it succinctly, if Kelly wants to write details down, the patient started to cry, the patient became agitated, the patient behaved aggressively, and Kelly wants to keep track of some of those clinical dynamics for Kelly as a memory jog, she's allowed to do that if it's a psychotherapy note. And under the law, Kelly does not have to share psychotherapy notes with a patient or client if they request the record. But Kelly has to be very careful to not include in that note any information about medication, counseling session start and stop times, the type of treatment she's providing, the results of any testing, summaries of diagnosis, treatment plans. So if any of that stuff is in Kelly's note, it's no longer a psychotherapy note. The only thing she's allowed to withhold from the patient or the client are those facts that I shared earlier. So I hope that helps.
Yeah, thank you. All right, and I am trying to take these questions in the order that I'm seeing them. Do you envision with advancing technology use in therapy that rules will change so we can provide support from a different state from clients?
I do, and it's actually happening. And I cannot give you a firm timetable. But in psychology, for any of you who are psychologists, there's what's called PsyPACT, PSYPACT, that will allow a psychologist who's licensed in Maryland, for example, to practice remotely to deliver services in Indiana. I'm making up those two states, if both states are part of the compact. Social work right now is moving in that direction. It's actively happening. It's not formally in place yet because each state legislature has to approve this. But the bottom line is, and that's called the Social Work Mobility Project. You can look it up. So the behavioral professions are definitely moving in this direction, but you got to be patient here. In the meantime, you're obligated, I think, to find out what the state the patient or client is located in requires in order for you to provide services there remotely. At the peak of the pandemic, many governors waived that requirement because they wanted people to get help. But most of those executive orders have expired. Maybe all of them have by now. What else do you have?
Great. Thank you. And I did put links to some of those compacts.
Thank you. Thank you. That was very quick and very good.
So this one is a little lengthy, so bear with me. When the sorry, my screen's shifting. When the American Psychological Association published a model informed consent document for psychologists so that we could all be assured of complying with HIPAA, it was 14 pages long. Obviously, that was wholly unrealistic. With the additional requirements you have outlined that are necessary due to technology, I'm wondering how long your informed consent document is, and can you recommend a couple of email and text encryption apps?
So the one I recommend is relatively short. There are lots of templates out there. And so the one that I recommend, I include in this particular book, which I'm not saying you should go buy it. Feel free to try to get from a library, save yourself some money. But if you take a look at this book of mine, Risk Management in the Behavioral Health Professions, a practical guide to preventing malpractice and licensing board complaints, if you take a look in the table of contents, you'll see at the end, I've got all kinds of sample forms. Some of them are embedded in the book itself, but I got a whole appendix with all kinds of sample forms. So the one I recommend, it ain't 14 pages long. It's like 2 to 3 pages. And I think that passes muster. But there are other ones out there too. I wouldn't use a 14-page one because I think the likelihood that a client or patient would actually read that thing is close to zero.
Yeah, yeah, I agree. All right, I'm going to see if it works for Ali Berger. I see that your hand is raised. We could give you permission so that you can be unmuted and ask your question.
Sorry, guys. I don't know how that happened. No questions. Thank you, though.
Oh, okay. Thank
Well,
you.
nice to meet you, Al. Nice to meet you anyway. Okay.
You too.
All right, we do have a few more questions. I think we have time for these three that came in through the chat or through Q&A rather. How do you feel about verbal consents that we receive over the phone and then reflect in a chart note once they're received?
So it's a short answer. I think you have to check with legal counsel in the state where you practice because some states, in my experience, will recognize a verbal consent without written consent. Others may not. I think if there are emergency circumstances, I think the standard of care is quite different, but state laws differ with regard to whether verbal consent is permissible. I would be checking with legal counsel to be sure you're not running any risk there. I know that's a pain, but that's what I would do.
And I'm assuming from previous comments that that is based on the state that the client and yourself are located in. So you might have to double
Correct.
check two states.
That is correct. That is correct.
Okay. And how are small NPO professional facilitators of drop-in peer support groups governed by these regulatory laws and standards?
So I would have to know more about who those facilitators are. Are they professionals who are licensed? Or are they paraprofessionals? Are they volunteers who don't necessarily have a degree? Kelly, I don't know if you can fill me in. Or is it all of the above?
That I think, I'm making an assumption. I think it's professionals, but
So,
that
okay,
detail.
yeah, all right. So let me make the assumption that we're referring to professionals here who are licensed. So those individuals, in my experience, will be held to the relevant code of ethics in their profession, the relevant practice standards. In fact, I'm going to try to pull them up real fast just to illustrate for you. Wait a minute, hold on here.
And yes, it is speaking to licensed professionals.
Okay, all right. So let me do this real fast because I know we're running out of time here. So, for example, these are the standards for technology and social work practice. And I chaired this task force that developed these, took us a year and a half. Social workers would be held to these. And it's a very long document, a very long document. Every one of these standards has a subsection that you'd be held to. And then there are code of ethics standards. I'm giving you the social work ones because I'm a social worker, but there are comparable ones: psychology, marriage and family therapy, counseling, and so forth. I think you'd be held to those. And then there are the licensing standards. And this is the document developed by another task force that I chaired, Model Regulatory Standards for Technology and Social Work Practice. And these standards are now in the licensing laws in many, many, many jurisdictions around the world. You'd be held to those. And I know it's a hassle, but if you're going to be held to them, my advice is you got to look at them and know what they say and act accordingly.
Yes. All right. And somebody did mention to me that we glossed over the question about encrypted email text apps. So my apologies, I went on to the next question too quickly.
That's okay. All right. So what's the question?
Do you have recommended technology to use for that?
Got it. Okay. Quick answer. I cannot ethically endorse any commercial product. I hope you understand that. But this is my advice. Put in your favorite search engine encrypted texting, encrypted email, and then add the word reviews, reviews. And I would look for reviews of all the different products that are out there. There are a lot of really good ones. And I would not read reviews sponsored by any of those companies because they're biased, in my opinion. I would look for reviews that have been conducted by independent organizations. An example, one's called Tom's Guide. I think that's very reputable. Tom apostrophe S Guide. PC Magazine. There's a whole bunch of, I think, objective organizations that have reviewed these. They tell you what the pros are, what the cons are, what the expense is. The good thing about capitalism in this instance is there are so many products out there, they have to compete. It keeps the prices down, and they're really not very expensive. I would not send a text message to a client or patient without using that kind of software.
Great. And we are at time. I apologize to the one remaining question. We will copy that and get you a response. But I just want to thank everybody for attending, and thank you to Dr. Reamer for joining us. It was a great first section for POPs. As a reminder, this was recorded, so it will be available on CSC's Zoom events and our learning and training website through February 10th. Just give us a few days post symposium to get those loaded. That will all be shared, the links to that post-conference as well. And if you wish to receive the continuing education, again, we'll be sharing the link to that throughout the symposium. But if you complete it at the end of the day, if you're only attending today, or at the end of the day tomorrow, it will cover you for the entire symposium. So thank you again for joining the session. We do have our expo that will be open in from 12:30 until 1 p.m. Eastern time. So please visit our sponsors and exhibitors and our CSC booths. We look forward to seeing you for our next session. Back in 30 minutes at 1 p.m. Eastern time, medical cannabis guidelines. So thank you again.
Thank you, Kelly. Thanks to all of you. Thank you for joining me, and thanks for the incredibly important work you do. Be well, everybody.
Thank you.